So the paper that I sent out, it's trying to tackle, I'd say, two topics. One is in general constitutional theory about constitutional individual rights, and this is scholarship that's been worked on recently by Stephanie Barkley, by Sharif Girgis, by Jamal Green, by Judd Campbell. And the other topic I'm trying to tackle is what was called yesterday applied originalism. I'm trying to answer some basic questions about how rights can get challenged and reviewed in 14th Amendment litigation. And so what I want to do in the time that I have here is to ask three thought experiment kind of questions, and then I'll say a little bit about how the paper tries to answer them, and then go over the paper's main claims. And if I have time left, I'll tell you, just ask some questions of you that I'm struggling with at this stage. So so assume that a state law restrains the exercise of a substantive individual right that's protected by the 14th Amendment. So the right to bear arms tested in Bruin. And a state or a municipality has restrained the right somehow. So in Bruin, there's a licensure scheme that requires people to apply for a license and demonstrate they have a special need before they can concealed carry. So, and there's no question that the right is indeed covered by the 14th Amendment. So again, Bruin. So thought experiment question one, why isn't the state restriction unconstitutional full stop? In Bruin's terms, why not stop after step one and say the law is unconstitutional? The right is a federal right. The state law or the municipal law sounds in state law. Why shouldn't the federal right override or supersede the state law? That question might sound like it's attacking a straw man, but I don't think it is for two reasons. First, Justice Black took a position like that about free speech. I don't say that he fully hewed to it in his opinions, but in his public writings and some of his, the language setting up his opinions in free speech, he came close to that position, and he said in the speech clause, no law means no law. And second, that kind of question, if you can think through the answer, it helps you understand better the character of rights and government restraints on them in the Constitution. So on to the thought experiment question two. Assume that the right has principled limits, and so since it does, then the state can't, or a municipality can make law that order the exercise of the right in practice. So the second question is, why shouldn't it be constitutional law that courts should defer completely to state or local legislation ordering the exercise of that right? And that's not like a straw man position either. There are a lot of property cases in my main specialty that come close to saying that, is most of all Berman versus Parker. So then in case law, the two most common answers to my questions have to do with the police power. So there are lots of cases saying that constitutional rights, especially 14th Amendment rights, may be regulated consistent with the police power. And that became a constitutional doctrine no later than Munn versus Illinois in 1876, 8 years after the 14th Amendment was ratified. So that then raises my third thought experiment question, why? Was Munn right? How can federal constitutional rights be limited by the police power when the phrase the police power is not mentioned in the Constitution? And if the answer to that question is the police power is part of the Constitution's background, then we need a much fuller account than exists in current scholarship about where the police power came from and how it informs the background of the 14th Amendment. So this draft tries to answer those three thought experiment questions. And now a little bit about the paper's argument. In the argument, I'm trying to follow the beginning of the old ditty, something old, something new, something borrowed, something blue. So for constitutional scholars, the something old and the something borrowed are the discussions of the treatises and the case law about free speech and the right to bear arms. I think for most constitutional scholars, free speech and the right to bear arms are relatively familiar focal points for discussions about rights in the regulation. Witness the first paper discussion we had at this conference with Joseph and Reese's paper. So the something new and the something blue is property. For a variety of reasons, property rights are treated like Cinderella in constitutional law. And we can argue whether it's a good thing or a bad thing generally, but it is a problem for the questions that I'm trying to answer in this paper. So let's say that what we're trying to do is to understand how the Constitution structures rights and their regulation. In Federalist 10, Madison says that the regulation of various and interfering interests in property is, quote, the first object of government, close quote. Now let's say the questions we're trying to answer about the police power. The first source to look at to understand what the police power meant to a competent lawyer in 1868 was Thomas Cooley's Constitutional Limitations. And the chapter on police and Cooley's limitation covers exclusively property cases. So now that I've asked my thought experiment questions and summarized the basic way I'm trying to answer them in the paper, let me summarize 5 claims I think the paper makes. So first, assume that Section 1 of the 14th Amendment secures robust individual rights. If it does, those rights aren't absolute in the same way that Justice Black in his public pronouncements talked about free speech. Again, that's been shown in previous scholarship, but that previous scholarship has shown as much working a lot with sources from around the time the Bill of Rights was ratified. This paper is confirming those insights, but showing that the same understanding is carried forward to when the Civil War amendments were ratified. Claim 2. Under Section 1, states retain authority to make laws that order the exercise of rights that are protected by Section 1 of the 14th Amendment. In his work on the Commerce Clause, Randy Barnett has translated the word regulate into make regular. So laws that regulate commerce make commerce regular in relation to the purposes of commerce. Regulate has a similar meaning when you're reviewing laws that are ordering the exercise of constitutional rights. Regulations make those rights regular. So even after the 14th Amendment was ratified then, states could regulate rights by making them regular in relation to others' rights and in relation to specific public interests. Now, lawyers in cases could refer to that state power to regulate the substance of Section 1 rights without ever using the phrase police power. And so one of the findings in the paper when I go for 3 speech cases is that no pre-1868 speech case that I've found used police power to talk about a just limit on a right to free speech. But the police power was understood by 1868 as a convenient shorthand for this idea of regulating rights consistent with the social compact. The word police came to American lawyers and statesmen through 18th century international treatises by Blackstone, by Vattel, by Adam Smith, and by Scottish treatise writers. And then over the first third of the 19th century, American writers and lawyers repurposed that understanding of police. I suspect that most people in this room are familiar with the use of the word police in cases like Gibbons and Ogden in federalism contexts. But while Chief Justice Marshall and other U.S. Supreme Court justices were working with police in constitutional federalism cases, state judges were using the same concept in rights-based challenges in state constitutional law. And that's the main and probably the biggest finding of the paper. So over the middle of third of the 19th century, that usage of police mushroomed in state constitutional law. A couple of right to bear arms cases invoked police to talk about, to review challenges to state laws on the right to bear arms, but mostly the usage mushroomed in state property cases. And so claim 4, when courts thought about, when they reviewed challenges to state-based constitutional rights, they assumed that there were 6 stable, coherent, distinct grounds for police regulation. And I can take questions and answers on those in the question and answer period, but I'll just assume that as much here. My study here is not exhaustive, but I think it's striking that across speech and the right to bear arms and property, courts were thinking about the grounds for regulation the same way consistently across 3 representative and important rights. The last lesson, all that background informs Section 1 of the 14th Amendment. Even after the 14th Amendment's ratification, states may legislate on, they may order through legislation the exercise of Section 1 rights. And the ideas about the police power and legitimate regulation that I've talked about, they inform the meaning of the word state in the Privileges and Immunities Clause and Due Process Clause, because a state is the sort of political entity that can make regulations. They inform the direct objects of these clauses, life, liberty, property, privileges, or immunities, and they inform, like the verbs abridge and deprive without due process should be understood as having implied exceptions or justifications. And with that, I'll turn things over to Michael. I'll look forward to any comments and questions you have.
Thank you, and thanks to the organizers for inviting me. Very frequently, when I'm reading drafts of papers, I'm irritated by how much they overclaim for themselves. This is an unusual paper because I'm not going to say I was irritated exactly, but this is the rare paper that I think underclaims. And I'm going to do two things. One is I'm going to suggest ways in which you might reframe the paper in a way which will make it much clearer how it applies to things that everyone cares about in constitutional law today. And then at the end, I also want to pose two substantive questions about your interpretation of the police powers that I just don't know. I'm confused. I don't know what you mean. So let me do that. But first, the issue of framing, because I think this paper, at the very end, your fifth point here alludes to this, but it shouldn't be your fifth point. It should be in the first paragraph. And beginning with the title, this paper is not about the 14th Amendment. This paper is about how to have a judicially manageable doctrine about the scope and limitations of rights, wherever they may come from. And it may even be about a few other things than that. For example, has implications for federalism. But the title says it's about the 14th Amendment, and then the first 10 pages, frankly, read as if this is going to be the second coming of Lochner and Hammer versus Dagenhart. I would cut all of that and instead cut to the chase of modern questions, because this judicial originalism, as opposed to academic originalism, is facing a doctrinal crisis. Strict scrutinies, tiers of scrutiny is on its out. I mean, we know that that's being rejected by the court, but they do not know what to replace it with. And your paper potentially offers a comprehensive answer to that. And even in specific clauses, I think your paper could have very interesting applications. Beginning with Bruin, a lot of the train wreck in judicial originalism has to do with the right to keep and bear arms. And you say in your paper that your analysis, quote, complicates Bruin, but you can say more than that. Your analysis actually suggests a better approach than Bruin. History and tradition, just waving one's arms at history and tradition, is not a doctrine. That tells us what should inform doctrine, but it doesn't tell us what the constitutional provision means. Your approach allows the court to generalize from history to analytical categories that are faithful to the history, but still provide judicially manageable standards. Bruin confuses a lack of regulation with evidence of a right. Your analysis, I think, does not do that. And I think, therefore, it would be very useful as a way of helping the courts to navigate these difficult Second Amendment cases. Free exercise of religion is also approaching a doctrinal crisis, because I think at least 5 members of the court have persuaded that that employment division against Smith was wrongly decided, but they are hesitant to pull the trigger because they don't know what's going to come after it. Your paper could be a very helpful way of getting into that. Now, your paper doesn't actually mention the free exercise clause, I don't think.
Yeah, I expressly say in 2 footnotes, not touching that with a 10-foot pole.
Well, but you should, because the state constitutional provisions refer to public peace and safety and protecting the private rights of others. Now, they don't use the phrase police power because, as your paper says, that vocabulary didn't come into vogue until 1840s, 1850s. Right, but it seems to me, at least, that your paper offers the promise that it could flesh these things out. And the thing I like about it, by the way, is that it does so in terms of categories and principles that are not historically. It's not embedded in amber. It's like these are principles from which we can now evaluate current problems and current needs. So I think free exercise is another area. And again, it's not just about the 14th Amendment. When people hear 14th Amendment, first of all, it's clearly also about federal rights. I see no reason why if you're right about the police power, no reason to think it applies any less to First Amendment rights against the federal government than to any right against the states. And what's more, although we all know that rights against the states are through the 14th Amendment in some weird way, most people don't. When most people hear the term, say it's about the 14th Amendment, they think you're talking about substantive due process. And they're going to turn it off because this is just not, it sounds as though you're engaging in a debate that occurred 80 years ago, when in fact you're engaging in a debate that's happening right now. So my suggestion to you is present this as a way of solving the court's current doctrinal problems with respect to rights across the board. Now, my two puzzlements. The first is that I understand that most of your cases tell us what things states can do, and then there are these, you call them 6 distinct stable categories. But I'm wondering what you really think. Do you really think that states cannot do things that are outside of those 6 categories? A concrete example of this would be anti-discrimination law, which I don't think fits within any of your categories and doesn't have any close analog to the kinds of regulation that was done in the antebellum period. Not that there weren't some anti-discrimination aspects to law, but there weren't statutes regulating private conduct in the interest of stamping out anti-discrimination. So I want to know, are these 6 distinct categories exclusive? And if they're not exclusive, then what really is your answer to the Berman versus Parker problem? So that's my first question. I know you think you have an answer to Berman versus Parker, but I couldn't pick up from the paper what the answer actually was. Second question is what do judges do when they're trying to figure out whether a particular law or regulation falls within the police power? What are they looking at? Are they looking at whether the purpose of the law or regulation falls within a police power purpose? So you refer, especially in I think some Lemuel Shaw cases, you talk about pretense of the purpose. So it sounds like we're talking about intent in some sense, but it also, I wonder, is there any element of an empirical examination as to whether the law or regulation actually significantly advances the supposed police power purpose? I think a lot of the Second Amendment cases are really about that. Every Second Amendment regulation purports to be defending people against violence. And so you have to look, it seems to me, to be useful for the Second Amendment, it has to be going beyond that. So it might be purpose, it might be some sort of empirical examination, which, by the way, makes me very nervous as a judicial matter, but it still might be. And then the third possibility is that you could be asking courts to judge whether the measure is proportionate to the purpose. So, but again, that has some problems. It begins to look like an old-fashioned interest balancing test. And if you look around the world at the way proportionality review is conducted, it's not necessarily something I would want to bring into American jurisprudence. But in any event, I just don't know how a judge is supposed to decide whether a given law or regulation is supported by the police power. I mean, it could be any of these things. Thank you.
Thank you, Judge. That was terrifically encouraging and helpful. I guess the first thing I want to say, in if I had one more minute, I would have had this long setup of joke about, like, I'm worried that this paper is going to go into the dustbin like Krosky's Politics and the Constitution that we read about. And so I'm presenting it now before all of you rather than writing it hold up in my office and then putting it out in the world to get feedback, because I am at this stage, I think I have something important. I'm not exactly how, like, I guess maybe to use a metaphor, I might be near the target but not over it, and I'm hearing from the judge a suggestion, here's where the target is, fly the plane that way. And that's where this paper is at this stage. Of other people have other suggestions. Yours is very helpful, but there might be other ones, and I'm interested in all of them. And I'm also interested in suggestions where you think I might be wrong. Now, I guess to your two puzzlements, I guess anti-discrimination, I'll use the example to try to address the broader question. So that would be, I think, in the category of like a law, it's like defamation or nuisance, where it's a regulation that's preventing harm by one private party to another. But then you have to ask the question whether the prohibition on the conduct restrains the liberty of the person who's accused of violating these norms more than it restricts, that protects the rights of the person who wants to be free from discrimination. And those are messy, hard questions, the same way review of hate speech laws or of laws that like give somebody the right to complain about really, really ultra-sensitive pollution. And so that's the general thrust of the kind of answer you'd have to. I think that I think you could pigeonhole anti-discrimination in. The questions of judicial review you have to do afterwards are not easy. And then to your question.
The broader
yeah.
question, are the 6 categories exclusive?
No, my guess would be not. I can't think on the spot of a 7th right here, but in principle, the idea is that, like, for folks like Shaw, the rights are permanent, but the problems that arise in practice between rights change, and so there can always be a different situation. And so to your second question about what do judges do, to some extent, I want to say that that's not so much about the meaning of the relevant provisions of the Constitution. It's more about judicial doctrine carrying the provisions of the Constitution into effect. But if we're talking about judicial doctrine, I think the judicial doctrine would address, would cover all 3 of the topics you talked about. Some purposes might not fit well at all under any possible set of facts within justifiable rights regarding police regulation. Some might, but then there might not be evidence showing that the problem existed on the ground. And then if there was a demonstrable ground with evidence, then courts should conduct some proportionality review. And then the details of that's hard. There are going to be hard cases that are going to test judges. That's my first reaction. And with that, I welcome questions. And as Lorianne said, since this is so gestational, I might answer questions in less detail than they were being answered yesterday, just to hear more reactions.
We were chatting yesterday about how we were both writing about the police power, so I wanted to ask you a question that I was puzzling over myself because I'm curious what your thoughts are, which is, it seems like after the passage of the 14th Amendment, as you move into the early 20th century, at least the commentators on the police power get, somewhat in response to being prohibition curious, get kind of more comfortable with using the police power to regulate for one's own good, and that seems to be a real shift. So I'm curious whether you think the police power scope can, pick your word, evolve, be liquidated, be better specified, or change in some way in one direction or another? And 2, does that affect how you think the 14th Amendment would operate if you would recognize that some shift had happened?
So, you know, we talked about the paper. I think it's a terrific project and touches on a lot of things. What I want to draw you out on is the relationship between the police power and the police. And the institutions of enforcement changed so dramatically during the 19th century that the content of the legal and social norms could well have been influenced by them. And my example is that the Portland, Maine police, the detective bureau there was established, I forget whether it was 2 or 3 a handful of years before 1850 when they adopt the first statewide absolute prohibition on liquor. All right, and I can see this relationship going in one of two ways. Well, so basically, before the 1830s, there were no municipal police of the sort we know now. There was always proactive enforcement for national security and revenue, but there were no undercover agents out there looking for trouble the way we have them now. As that capacity comes online, it could go in one of two ways. If you get your jollies by regulating your neighbor's life, you might be really excited about this because now you can do it, right? On the other hand, if you were afraid of your neighbor regulating your life, you might think that the police power should be constrained and limited because now your neighbor can run your life.
My question stems from page 8 in your justification for looking at property and free speech. Maybe some of Judge McConnell's reaction sort of animates my response here. But you say that we should look at the particularly favored and disfavored rights. And you say that these two rights, property being disfavored, free speech being highly favored, from the 20th century, we learned this, but I'm not sure if that's a strong enough justification for me, at least reading, why we need to worry about what happened in the 20th century when we're looking at the 18th and 19th century is important evidence for understanding these rights. Now, I could think of justifications, let's say, on classical liberal foundation type justifications for property and speech. They might just be the very kinds of rights that are especially important for a liberal regime in protecting those rights, which is why they're especially important. But if that's not just the justification, I don't know. Are there other rights that might actually interact with the police power completely differently than these two? So anyways, if you could just talk a little bit more about your justification or why we might want to introduce another kind of right that's different to help see that the police power operates in the same fashion.
So to Bradley, my justification is just, there's a lot, I use the word anachronism a lot in the paper, and so there are a lot of expectations that modern readers have about certain lines of cases, and I think, I was hoping that by giving moderns one case that's low scrutiny in Caroline Products footnote 4 and another's high, the reader would then, it would force readers to then think, well, these people, these lawyers back then, they thought of these rights as parallel and they didn't draw these differential treatments, and that might help readers to see that for pre-1868 judges, the principles of regulation stayed more or less the same across different doctrines. It's just mostly to educate, to help persuade the modern reader. To Don, the principles, the police power principles I think I work with, I think they could be used in both of the spirits, the nosy and the hands-off spirits. It's like they provide a broad framework, and then different communities then can have arguments about how the framework ought to be applied. And to Christina, page 13, footnote 2, that's another topic. I say I'm not touching this with a 10-foot pole. I want to bracket the question whether the principles can evolve if some scholars here want to take my work and then say these materials show that the police powers could evolve. I'm fine with that. I don't want to take that fight on.
I just wanted to emphasize part of Christina's question that I thought was very helpful, which is she referred to laws to protect the self. I call these paternalistic justifications. And I'm really not sure how, I think the police power did not, in fact, extend to paternalistic justifications. And so it's another thing, like anti-discrimination laws, that fall outside, and I'd like to know your position on whether they're just out. In free exercise, I think that would work really well, except in a couple of really extreme cases. I used to teach a snake handling case, and it kind of tests the limits.
Okay. Well, on paternalism, the prohibition cases that I've read, they don't say the police power justifies paternalism. They instead say alcohol consumption leads to alcoholism, and downstream of alcohol is pauperism and crime. So I think that the two answers are, first, paternalism is probably not allowed, but then the next question is, can someone who supports a paternalistic project make an argument that this kind of behavior leads to the downstream social effects on the public morals or people's rights? And that's hard to settle.
Thank you for the paper, Eric. there's a lot in it with which I fully agree, and I really appreciated Michael's very illuminating comments. So I have a question or suggestion about your treatment of due process versus privileges or immunities. And the first part of this is just a query. What is is there a functional difference between the two clauses as you understand their meaning? What is it, right? Because that would be important to the next thing I'm going to say, which is, I think that your current treatment of substantive due process gets you into a thicket that you don't need to get into. So, you know, you think Ryan Williams has shown that Weinheimer establishes a certain kind of substantive due process. I don't think so, and I think that indeed the very quote that you excerpt, TAN 341, shows why Williams is conflating law of the land provisions with due course of law provisions and due process of law provisions, but those provisions all had different conceptual content. So that's sort of on the originalist side, and then you're taking on substantive due process, you know, just as a matter of impact and the way the paper would be received by judges. I think that substantive due process is not faring well, and that, you know, on the court, you know, there's one set of reactions to substantive due process grounded in Glucksberg that's inconsistent with the approach that you're advocating, and another originalist approach exemplified by Justice Thomas that rejects substantive due process and endorses privileges or immunities instead. So I think the paper would be more impactful if you downplayed substantive due process and relied more on privileges or immunities, unless there is some functional difference you want to point to. But if you want to go substantive due process, I don't think that what the paper does now is sufficient to establish the conclusions that you're reaching with respect to the 14th Amendment due process of law clause.
Great, fantastic paper, very, very thought-provoking. I had a possible, it might be an amendment, it might be a correction. You spoke in your comments, as in your paper, that deprive and abridge have implied exceptions. And I gather from that you're taking provisions like the anti-infringement, anti-abridgment provisions of our First and Second Amendment, or the Privileges and Immunities Clause, to have three steps. First comes a right, then comes a don't abridge, don't deprive, and then comes an exception. And I want to suggest first, as texture, as to the abridgment clauses, that would require taking a two-step clause and put a third thing in it. And one of the ways to reframe this, perhaps radically, but perhaps it's consistent with what you're saying, is that when you speak about the right to bear arms, to freedom of speech, the right to acquire real as well as personal property, they already include within themselves reasonable purposes. And with respect to Corfield in particular, the subject to reasonable regulations is a discussion of the life, liberty, happiness stuff. But then the next sentence, when he talks, actually enumerates privileges and immunities, he has ones that are, you might say, pre-regulated. Right to travel for lawful purpose, right, privilege of writ of habeas corpus. That is to say, you can, and what the police power does isn't to abridge those things, but defines what is already the right itself, if that makes any sense.
John.
Eric, I now want to read the article that's titled "The Powers of Congress and the Fifth Amendment," because the Fifth Amendment also says no deprivation of life, liberty, or property without due process of law. And Congress and the national government, even if they have an unenumerated power to act on national matters, don't have the police power, which can operate completely locally. And yet it must be the case that the other powers of Congress, the list and maybe whatever else is there, can operate on life, liberty, or property. So I wonder whether the real principle is all rights, life, liberty, or property, whatever else, are held subject to the powers of government, whatever they are. and that the police power, the eminent domain power, the taxing power were theories developed in the 19th century about what the powers of the state governments were, and that they're basically principles of state constitutional law, and they're not found in federal constitutional law.
So to John, I agree with most of what you said. I guess this paper is focusing on the 14th Amendment. So these state powers that are found in state law, I think they become backdrop for understanding the 14th Amendment. And I agree with the general account you're giving of the Constitution of 1787. I just don't prove that in this paper, I don't think. To David, I think I agree. I'll want to follow up with you to make sure I get your formulation right. And I guess to Larry, I didn't mean to write the paper, that passage the way you read it. I guess when I was writing more to a group of academics saying whether you are whether you endorse the fundamental rights reading, the substantive process reading of due process, incorporation under either. If you take it by any of those four, then what I say about the 14th Amendment carries through. What you're saying to me is worry about the judges, and I will take that very much under advisement. That persuades me. But like in that passage, I said the due process clause might have a substantive component, and that has enough support to survive academic summary judgment. And then right after, I say if, with hyphens, the substantive reading is correct. So in those passages, I was trying to say I'm not going all the way that Ryan goes the way you read me to. But some of that's going to depend on whether I reframe the paper as Michael suggests or some other way. But I will think very much in future drafts about how it will be received by judges.
So a comment and then a question. The comment is, and this builds on the colloquy with Christina, that I liked your response and also the response you gave to Michael, that when we're thinking about these problems, we want to think both about the questions of abstract constitutional meaning and questions about judicially enforceable doctrines. And that's a really important distinction. And my comment is simply to say all the source material in this paper was grappling with the same set of conceptual problems. They don't talk about it, but anytime you're citing a case from the 19th century, it's going to be thinking about what the underlying principles are and what the role morality constraints of judges are. And so it's just really important for us not to read these cases as if they were somehow the true meaning of social contractarian principles applied to questions of constitutionalism generally. I mean, these are source materials that are shaped by the judicial norms that were applicable at the time. So that's not to critique anything you're saying in the paper, but just when we're thinking about this general problem, what is the scope of the police power? The answer that we might get to that general problem from first principles might be different than the answer that we would get from the source materials that we're looking at here. And then the question is very much in line with what David was saying, which is, aren't there different types of rights that impose different types of constraints on governmental power? And isn't that reflected in the way that you see the speech cases being described differently as opposed to the gun rights and the property cases? So you treat the speech cases as articulating a framework that uses as you put it, term of art that is in substance equivalent to the way the court's dealing with the property and the gun rights problem. But I'm not sure that's right, and I was wondering what your views are as to how to think about rights that have more determinate legal constraining effect on governmental power. Here I think that rights of conscience would be a really nice one to look at, because they are, I mean, my view is that they have a conception of the limits of the governmental regulatory power with respect to conscience that's just much thinner than it is with respect to other rights.
Don't listen to the judge over much. So I guess I want more 14th Amendment. I also want more stuff about the Bill of Rights. Yeah. So if you could have, you can change the title. Maybe my advice about titles is famously bad. But you could have it be about the police power, but then really drilled into the meaning of citizenship. I loved the paragraph, it was too short though, about the etymology of police and body politic. I think if you really expanded that out, you could get a much better textual hook into citizenship. So the kind of thing you could talk about with the bill. So I think I feel like you need stuff to connect it to like the Bill of Rights as such. If you're going to really get into the federal stuff, stuff like the preamble to the Bill of Rights. We're adopting this in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. To the extent you're going to add a kind of really Bill of Rights part, that kind of thing, but then in terms of kind of hooking citizenship into the body politic, you mentioned MUN. I mean, you could make a lot more about this. Preamble to the Massachusetts Constitution. I love this. The body politic is formed by a voluntary association of individuals and is a social compact by which the whole people covenants with each citizen and each citizen with the whole people, that all shall be governed by certain laws for the common good. Essentially what the 14th Amendment is doing is saying, take what Adams said in 1780 seriously for all states. And the police regulation, the kind of things that make us into a political, a body politic where we're all in this together, that's the natural outgrowth of something that promotes citizenship. I think you're wrong about paternalism, minors and minors. Holden versus Hardy, all the prohibition cases I cite in my paper. It seems like the government's acting, for the better good of its citizens. Children, I mean, they're citizens. They're citizens from birth, right? But obviously, both parents and general laws can act in their best interest, contrary to their desire.
So the police power is a rhetorical stratagem for upholding an exercise of government power. Another is the pre-limitation strategy that has already been discussed, which I think you're very hard on Hugo Black, but I think this is how Black operated. Black dissents in Cohen versus California, in which the whole gravamen of the charge is that you used a word you shouldn't have used. How that is not speech, it's mysterious to me. The free speech is absolute, but certain uses of offensive words just aren't speech. So we've got these two different strategies for upholding the exercise of government power. I am curious, and I think that I'd like to see the paper say more about why judges sometimes use one of those and sometimes use the other. They're both ways of reaching the same result, that the statute is upheld. Another tension in your sources that I just would have liked to hear more about is there are repeated references to an understanding of the power as fundamentally about protecting rights. We only can restrict rights for the sake of general protection of rights. So on 21, you talk about Michael Zucker's idea of rights infrastructure, where you can look after traits of character, maybe even prohibit alcohol, if that's what's necessary in order to have the traits of character that make rights securing possible. But it's also taken for granted throughout this time that one of the legitimate uses of the police power is protecting health. So you get a case like Jacobson versus Massachusetts, but no one's rights are violated by the smallpox virus. So the state has other concerns besides protecting rights. It's just bad luck if you get smallpox virus. You can't sue the smallpox virus. It's just not a participant in the discourse of rights. So this just seems to me to be an internal tension within the police power discourse. I think that last thought there's a tension between the enterprise of historic excavation and the originalist enterprise of coming up with news we can use, and it excludes the possibility that the 19th century conception of the police power is so weird that it's really not useful today, and we're going to have to do something else.
Well, I don't think you should you should worry over much about comments by people named Chris. No, actually, so what Chris says, I think, suggests that maybe they're two entirely different papers. I'm suggesting a paper that is relevant to modern constitutional law. Chris is suggesting a paper that is relevant to deep thinking about the 14th Amendment and other things that are really important to academics, but are completely, not on the horizon for judges or lawyers or anyone else living in the real world. So I'm suggesting how to make a paper that people are going to actually be interested in reading.
And who else will take up? Okay, here we have it. Eric.
So to that, I mean, again, I circulated, this draft is, it's on its way, but it's got a ways to go. And I was hoping to get exchanges like this. I need to make up my mind. I need to think about some possibilities, what the target is to which I'm writing. So I'm grateful for the exchange. To Andrew's question, on the one thing I guess I'll say more about here is that why was it that in the free speech cases, courts tended to use what he calls the pre-limitation strategy? So I don't have a complete answer to that. On the basis of the cases that I looked at, Andrew, I think it's, in speech, there's just, like the early cases thought that there were well worked out limits to the common law right to free speech, and then it becomes path dependence where the cases in the 1830s are saying in 1810 they said that there's a common law limit on the right to free speech, where there wasn't a lot of gun rights case law to work with later, early on, and then in property, the idea of police gave a hook, and so it's just path dependence across those two areas. I could be wrong, but on the basis of what I've seen, that's what I think. Chris, thanks for the suggestion where to take the paper next. That's 2 suggestions I've got. I'll take more. And then to Judd, I'm happy, I'm gratified that he and I are seeing things the same way, that there's a difference between constitutional meaning and the method of adjudication. I think that the history and tradition and interest balancing debate is like there's a lot missing because it's not appreciating those 2 different functions. And I grant that there are different kinds of rights. I guess the ones I picked because I thought they'd be ones where there could be lots of grounds in practice for them to be regulated. So you'd get tests. And conscience would be one, it'd be hard for me to imagine many grounds to regulate it.
Well, the paper I think you should write, Eric, the most important thing I think is you have to put down all these 10-foot poles. Because the paper is currently written very defensively as if it doesn't want anybody to read it. And I think you just got to get into all these things that you have views about and are casting light on, and that includes free exercise and a bunch of other stuff, to the extent you have things to say about them. And I think the most useful thing you have to say, actually, is to continue this exchange with Judd about judicial review. So I think everybody serious, which doesn't include the Supreme Court, already knows that rights can be regulated in the public interest. And the question is, how do we operationalize that, right? And some people would say, look, judges just really can't do very much about that, because as long as the legislature says we have a good public interest reason for doing this, which they almost always will, the judges kind of have to accept that. And if you don't do that, then you're going to have a purpose test, but that's very hard to operationalize, because again, they're not going to admit when their purpose is something that's not within the police power. Or you're going to have a Bruin-style limited set of historical analogs you can use to regulate. That's Michael's question to you, but you say no. You can have new public purposes and new public harms, probably right. And then at that point, it sounds like either the courts just have to accept all of that, or they have to ask whether those things are actually true and actually work, in which case you're doing Lochner. Now, maybe it's fine to do Lochner, which is another one of the 10-foot poles you probably have to put down, right? But I think the million-dollar question in Lochner was, how much should the court actually ask about whether this regulation is within the police power or not? And there are plausible views on both sides. And of course, the court has to, otherwise rights won't mean anything. But if the court does, we have government by judiciary. And the amazing thing about the body of material you have is the courts actually spent a long time trying to answer this question. And so it would be ridiculous if we acted in the 21st century as if nobody had ever asked those questions before or struggled with them for decades. And so you should tell us what the answers are that emerged from their struggle and who was right in Lochner and who was right in Lawrence.
Great paper. I'm sort of torn between the Chris and Michael McConnell's view on what how the paper should be framed. I think that the police power is absolutely essential to understanding the original meaning of the 14th Amendment's Privilege or Immunities Clause. Any originalist project, such as Justice Thomas's, to go forward with the Privilege or Immunities Clause cannot avoid the police power question because it's part of what defines the scope of the privileges or immunities. And so this really is crucial to the 14th Amendment. The 14th Amendment just doesn't get off the ground without this conceptual development that you're investigating, and what I think Will is right about all that. However, having said that, I think the actual implications of this theory go well beyond the 14th Amendment to, for example, the scope of the rights that are in the first 10 amendments. And also, I will add something that hasn't been mentioned, and I think maybe I disagree with John Harrison's formulation a minute ago, and that is where Congress has the power to regulate the liberties of the people, it is like a police power. It's a limited police power, but it is a police power, which is the way I teach Champion versus Ames about the prohibition on the interstate carriage of lottery tickets. Because I think what Harlan is doing there is, without using the term police power, what he's saying is Congress has a power over interstate commerce. The states do not have a power over that commerce. The states police, therefore, if the states don't have a police power regulating the rights of commerce, the activity of commerce, and Congress doesn't have the right to regulate commerce according to a police power, then nobody does. So interstate commerce goes completely unregulated in terms of protecting the general health, safety, and public morals. And so what Harlan is advocating for is a limited purpose police power over commerce in the form of the power regulation. All the concepts that the courts were wrestling with, to the extent you can bring them out and help us reach some proper conclusion, is going to apply to the police power that it's in the commerce power, the limited one, as well as the general police power that the states have. So again, I think it's absolutely crucial to our 14th Amendment project that you do this, and I think it should be labeled as such. I kind of agree, maybe more privileges or immunities, but also it permeates everything precisely because there is now a consensus that an increasing agreement that liberties can be regulated for the common good.
Thanks, Eric, for the paper. Enjoyed reading it. One sort of recurrent and sort of intriguing theme I saw through the paper was this thing that Andy mentioned, the concept of the rights infrastructure that Michael Zuckert sort of talks about. I wonder whether that could sort of serve as a unifying theme for the paper that you could perhaps kind of bring up front. It seems to be an important piece of your understanding of the police power, which traditionally we talk about it as just the power of the state to regulate health, safety, welfare, and morals, but you are putting on a caveat for all those things, but for the sake only, ultimately, of the protection of individual rights. I would love to see maybe two defenses of this rights infrastructure concept without just simply referring to Michael Zuckert, like a philosophical grounding of this idea of the rights infrastructure. Like, would James Wilson have sort of bought into that kind of more narrow or cabin view of the powers of police power over the states, and more of a historical grounding too, maybe in response to the comments of maybe Randy and Evan Bernick, a little more engagement with kind of the cases of the 19th century that do seem, in some cases, to not do the rights infrastructure approach, but are more open, perhaps, to a more sort of paternalistic or perfectionist approach to rights regulation.
Thanks. All of this I'll take under advisement. So to the point that I'm trying to avoid too many things with my 10-foot pole, I only have 30,000 words at most, in one sense, and in another sense, maybe I've got a couple of different projects here, and I'll have to think about that. To Derek's question, I hoped that there's a passage I quote from the end of the Virginia Declaration of Rights that explains the grounds for regulating for virtue, temperance, morality, and other things. Frugality. I was hoping that would illustrate, and I'm hearing it didn't illustrate well enough for you, and I'll have to think about whether I can I can elaborate more without that part of the paper swallowing or occluding a bigger theme. To Will, thanks for the comments. That's more I'm taking under advisement when I figure out what I do with this draft and with this broader research project.
Michael?
A small point and then a larger one. A small point is about this business of saying the things you're not going to address. You don't have to address things, but the way it is put currently, it makes it sound as though you're not addressing them because they're too hard and don't really fit into your theory. And that makes the reader think that your theory is like really porous and not comprehensive. So if you're not going to, instead say this could easily be extended to blah-de-blah, but but that's another paper, or I don't have time, or whatever. But don't make it sound as though these are things that are just too big a problem for you to deal with. The slightly larger point is that both Will and Judd, I think, said something very similar but very helpful, and maybe it would be useful to spell it out early on, which is the way in which what you're talking about is operationalizing, or I talk about judicially manageable standards for this idea of the common good. So, Judd is mostly writing about pre-founding materials, and the idea that rights are regulable to promote the common good makes a great deal more sense in a world in which there's a lot of consensus about what the common good is. But when that consensus begins to break down and you have legislation that is, of dubious relation to the common good, and I don't mean bad, I just mean people are going to disagree about it, it seems to me you need something more than that. And it seems to me, at least, that your project can be seen as carrying Judd's basic approach to natural rights up to and including the 14th Amendment, but now in a world where we no longer have consensus. But it's still, I'm still thinking you haven't solved the Berman against Parker problem. Like, what are you going to say to people who can come up with a clever a connection between a regulation like the one in Berman and the common good?
So Eric, I'm just going to continue on the theme of saying that I think right now the paper is, which is wonderful in its historical treatment, is a little unfocused about what is the through line, what is the actual goal here. And it seems to me there are many possibilities, all of which are kind of touched on in the paper. One is figuring out what is the conception of rights in the early 19th century all the way up until Reconstruction. And that's sort of like the kind of big conceptual work that Judd does at the founding, right? You could be asking, what is the understanding of these particular rights that you're focused on, like free speech and the Second Amendment? A third would be, what is the understanding of the 14th Amendment? Another one would be, well, what is the relationship of these things to particular ways that constitutional text can declare or specify types of rights? And then another one would be, what does any of this have to do with the doctrinal questions, like what the right methodology for translating this into the adjudication of constitutional claims? That's the point that Michael's making, right? My own advice, for whatever it's worth, is that you pick one of these as like the clear purpose of this paper, and I would suggest the methodological one. I actually want to echo Michael on this. I think that you could slim down a good deal of the paper where you're making claims that are certainly well stated, but are not necessarily as contestable as a matter of modern doctrine, and make more room for a treatment of what are the implications of all this for Bruin and the different understandings of the Bruin test. What are the implications of it for something like Dobbs? These are different historical tradition tests with different assumptions built into them, and the history you're canvassing here might support or counteract some of these. So just very quickly before I leave off, I actually didn't find a lot to object to in what you were saying as a defender of Bruin's methodology, right? You say this complicates it. Michael thinks that it more than complicates it, might even refute it. I actually don't think so. I think a lot of what you're saying is very compatible with the Bruin methodology, properly understood. But I also think it's not compatible with some understandings of the Bruin methodology that I think are just wrong, right? And so, anyway, I think that a final part of the paper that really just dives into how best to think about the methodology would give a payoff to the paper that makes all this well worthwhile.
Thank you.
So this is going to actually synthesize a bunch of comments. I think you should go big. I think you should write a paper, I don't know, call it The Origins and Scope of the American Doctrine of Constitutional Law, the second, or whatever. You'll get cited a lot in 130 years. And you should say, all these disparate doctrines, dormant commerce, the federalism cases that I've talked about and that you cite, Bruin, First Amendment, substantive due process, it turns out they're all explicable under this concept of the police power. And the police power is a better way to think about this. It's how they thought about all of these cases in the 19th century. And what we're missing is an explanation of what those powers really were and how the courts decided what they were and what the role of the courts were with respect to enforcing those rights. And that's like what your paper is doing. And then look at all the potential applications to Bruin, to First Amendment, to Dormant Commerce Clause. And I just think that would be just like an insanely, hugely useful project and probably highly cited. But so I want to add another 10-foot pole that you should use. For example, doesn't your discussion of morals explain why the court was wrong in the pork producer case, in the Ross case? Right? I mean, like, even if you do the rights infrastructure, you limit it to rights infrastructure, but even if you accept, what was the other one, paternalistic kind of view, can we agree that passing a law because of moral disapproval of what other people are doing in other states isn't about regulating the morals of your own people, and therefore it is this interstate commerce power that was supposed to be exclusively granted to Congress? Okay, some people dispute that proposition, but assume it for sake of argument. And maybe you're wrong about what morals really are, but the point is you're giving an explanation for what this was. And here is an application of how a case would come out cleanly and easily and could have been 3 paragraphs and everybody would have signed it, maybe.
Okay, let's suppose you're right that about the original meaning of these rights provisions and they permit the rights to be regulated in ways that are consistent with the social compact. Then in order to apply these provisions, we need to know the content of the social compact. And I wanted to hear more about that. How are we supposed to determine what the content of the social compact is? I mean, for example, should judges look to the views of people who were alive at the time these provisions were ratified? What did they think the content of the social contract was? If so, which people? Are we looking at the drafters of the provisions? Are we looking at the views of the people at large as represented by the people who ratify these provisions? What if there's disagreement? Not everyone was operating on exactly the same political theory. I'm sure there was disagreement. How do we adjudicate those disagreements? Or should judges be trying to sort of like discern what the content of the actual social contract is? And if that's the case, or really either way, I mean, what do we do if we think the best political philosophy teaches us that social contract theory is ultimately misguided? A lot of political philosophers think this. It's, they're just fatal internal places where it's internally incoherent. How much philosophical cleanup work should we do? For example, you get a very influential theory like John Rawls's, which claims to have some predecessors in the classical social contract tradition, but nonetheless isn't just like a restatement of them, but he does a lot of cleanup work, and by the end of it, it's not clear his theory really counts as a social contract theory. So how much cleanup work should we be doing if we see some internal tensions or contradictions either in the thought of the relevant people who drafted or ratified these provisions, or in social contract theory generally, if we're judges and we're supposed to look at the true theory rather than just follow the views of some people or some subset of the people who were alive when the provisions were ratified.
Thanks. Just a quick comment, Eric, that elaborates on something I said to you on our cab ride in from the airport, which was that I was struck by the juxtaposition in the paper between the very big, bold way, actually, I think you start locating the origin of the police power in the law of nations and in the independent, sovereign, national status of the states, with reference to people like Vattel and Smith and Blackstone and so forth. But the later parts of the paper, I think, make clear that what you're talking about there, the working out of the police powers, in large measure, bottom-up working out of the sic udere tuo maxim by courts, and then a legislative power that necessarily can come along and declare and shape and override that. And it seems to me that that's really what you're talking about in the paper, that somewhat questionable, debatable introduction where you're making these bold claims about the origin of the police power seemed to me not to do that much work later on, and I wonder if you're giving yourself a vulnerability there where people are going to kind of get distracted and question that when actually it's really not essential to your project.
Yeah, so one of the thoughts I had is we were talking about the difference between constitutional meaning or constitutional theory and then judicial application, that if you choose to focus on the 14th Amendment, I think is just sitting right there for you is Section 5 in Congress's power under the 14th Amendment. So to the extent we think police powers were actually fairly limited, you could make rights arguments in the legislative context or in the public sphere that you couldn't necessarily make in court. Where does Congress fit on that continuum? And can they identify excesses in the state's police exercise of police power that judges couldn't otherwise? And then how do judges assess those determinations, et cetera, et cetera? But I think to the extent that you focus on the 14th Amendment and judicial doctrine, that wrinkle, I think, is you have to at least address a little bit with a 2-foot pole.
The short answer is Judd suggested this distinction between meaning and then adjudicative theory to implement meaning. And here, I think the same answer applies with qualifications about Congress. Like the Constitution, if the police power is part of the background of the 14th Amendment, then whatever arm of the federal or government and any state government has to act on rights that are implicated by the 14th Amendment has a responsibility to figure out what the 14th Amendment means and apply that meaning. And so Congress then can get into constructive arguments with federal courts and with states about what the rights are that are covered. And I don't think I can say much more than that. To John, I think you got me. Like Blackstone and Vattel and others, they talk about police power in terms of ordering, and they tick off a bunch of examples, but they beg a lot of questions. And you're right then that the cases, they're trying to work bottom up, and so. But I guess I would say that right now I'm inclined to think that if 1868 the police power means what the best approximations of its meaning are going to come from the seminal cases like Shaw's opinion in Commonwealth versus Alger, and in Cooley's the 3 or 4 pages giving an overview of the police power. And I think that's a lot of the answer I give to Charlie on one of your questions. That a lot of your questions I'm not too worried about because they're just problems about original meaning analysis anyway. Like who you're going to pick, you could ask that just about any. It's just that the problem here is that the different sources you can work with can point in different directions, and that's a problem. But that's a problem to the method, not to this particular problem, I think. And then to Alon, I guess here I don't want to go as big as you're suggesting because I only have 30,000 words. And I guess I'd want that, like, I guess whatever I focus on, I want the parts of it to be, like, all to be relatively close together. But I just want to, at that point, did I miss anybody? To Joel, your taxonomy of the 5 different half-through lines I have is very helpful. Thank you. And with that, I'm thankful to everybody. Again, I said I was hoping to figure out what to do next with this because I was not sure. Joel also was what my through line was. I got a lot of great suggestions about that and a lot of friendly warnings. Thank you.
Thank you all for your participation.